Hello, this is Jim Blackburn, and I am getting ready to talk with you in what is actually hour two of a 3-hour continuing legal education program for the bar for both attorneys and paralegals, and it's on the subject of good to great lawyers, paralegals, and clients. And I do this program essentially through the view of myself when I was a client back in the early to mid 1990s, and Wade Smith and Rick Gammon, both of Raleigh at that time, were my attorneys. They were also my friends. I also talk a little bit about the relationship that I had as a patient with Dr. Gene Spalding of Durham, because there's some similarities, not completely, but some similarities in that relationship as well. I started out in hour one by saying that my definition of what becomes a great attorney, or really a great paralegal, is someone who helps or assists the client in having a better situation at the end of the legal representation than was present when that representation first began. And if you use that rather broad look at the whole relationship, then most any attorney and most any paralegal can indeed become great, frankly. Now, in order for this program to be approved by the bar and to count for CLE credits for both lawyers and paralegals, it has to be interactive. And so I do that in a couple of ways. First, let me give you my telephone numbers and email address in case while you're watching this program you have a question or have any difficulty. You can call or write me and we can talk about that. My email address is jim@blackburnseminars.com, jim@blackburnseminars.com, and my telephone number is area code 919-326-9070, 326-9070. And my cell phone number is 919-889-7316, 889-7316. Now, in addition, in order to ensure that you actually view this program, I will have, during the pendency of the whole program, a couple of questions that I will ask, and ask you to answer them and let me know either by phone or email that you've done so or can do so, and therefore I know that you've watched the program in its entirety, because you don't know when the questions are going to come, and I can then turn your name and time and everything into the bar for you. Now, that having been said, let me just go back and relax here for this next hour and just talk with you in terms of telling what it was like for me being a client. It's hard to believe, but there was a time when I was an attorney practicing law for more than 20 years. A large percentage of that time, though, was spent in the government, with the Attorney General's office and the United States Attorney's office. When I first became a lawyer working in the Attorney General's office in the early 1970s, my first job responsibility there was to advise various state agencies in their legal representation. We had a relatively small office at that time. We had about 60 lawyers, which was big. It's now multi-hundreds of lawyers there, but there was about 60. And so I got to do a lot of things and talk to a lot of agencies. Sometimes they would come to see me in my office in the Attorney General's office. Sometimes we would talk on the phone. Sometimes they would write me letters. But always they had precise questions they wanted to talk with me about. That might be the Real Estate Licensing Commission, which I represented for a period of time. It might be the state retirement system, which I represented for some time. It might be various licensing boards and licensing agencies that we represented before they now got sort of their own counsel, as they now have admitted counsel. But back then, it was the Attorney General's office, because a lot of these licensing agencies were coming into being really around this very time. And I remember I didn't have the demands of billable hours. I knew what my salary was going to be. I didn't depend on these clients for money. I did depend on them for work, and they were assigned to me. They didn't have much of a choice as to who they got, and I didn't have much of a choice as to who I got. So it was sort of a forced marriage type situation. And you have to make the best of it. I think I got along with most everybody pretty well. And even then, you can learn the seeds of doing things in the correct way. When someone writes you a letter and wanting an informal opinion about whether they can do or not do such things, or whether this would be appropriate, you need to give them appropriate representation and answers to their questions as soon as possible. Sometimes it would take the form of a letter, some detail. Sometimes it would just be a phone call. But I learned then, in those early 1970s, those first 5 years of practicing law in the Attorney General's office, the necessity of keeping clients happy and on a good relationship with you, and so that you didn't mind if they walked in to see you, or if you saw them on the street, or you went to their office. And you can learn good traits right then. And learning good traits and how to deal with clients. They're not going to be your friends, necessarily. It's hard to believe, but when Wade and Rick represented me, they were my friends. I think it, frankly, is hard to represent a friend and do it well, because the expectations are so high. If it doesn't work out the way you hope it will work out, it may damage the friendship. Whether or not the client who's a friend expects more from you than you're able to give, and that sort of thing. But that's a real issue, and that's a real problem. And so I think if I had to say it to you today, I would err on the side of not representing friends too much. Maybe give them a great recommendation to someone else, maybe even someone else in your law firm, but you might want to take a hands-off approach to that. It's hard to be friends with your clients. If you suppose you get a new client in today, and it goes on for some time, and they become your friend. They want to have lunch with you. They want to have coffee with you. They want to see you and talk with you and even socialize with you. That's a dangerous thing to do, because it's not that they're not nice people, and under other circumstances you might very well be their friend, but it's not a normal friendship relationship. It's an attorney-client relationship, and it's one where the attorney is being paid by the client to do a specific job. And the danger is, if you want the client to do what you suggest and say and follow your lead and direction, you can't really go outside that relationship. And if you become buddies or friends or social friends, then that may hurt your ability, it seems to me, to get the client to do what you think the client should do, or the client to follow your advice or respect you even, or to lash out at you if things don't go right, or to think that you really don't mean it when you're saying something really tough and strong to them. You need to be in charge. And the attorney-client, it's not an even situation. I know that the client is important and is paying you an income or a fee to represent them, but you've got to be in charge. You've got to be the one who calls the team. You've got to take their advice and listen to what they say, but you've got to lead. If you don't lead, the train is not going to go anywhere. I remember in another case, a criminal case, that I was not involved in, but the lawyer was. He was having lunch with the wife of his client. And the client was in custody, in jail. And the wife was emotionally upset at lunch and said, "We've just got to get him out. He's our friend. We've just got to get him out." And the lawyer said, "No, we can't be his. I can't be his friend. I've got to be his lawyer. And I've got to look out for him that way. I can't be his friend. And I think that's true. I have said and believe that you need to have a good relationship with your clients, which I do think is very important. But I do not think it requires that you become their friend, because I think that jades your advice that you might give to them. Sometimes clients come to see you because of your reputation, because you have a good reputation for handling certain matters. And you know, you always get this line, well, you did really great in that case. And that case was harder and more complicated than the case I'm in now. And so, can't you do this for me since you did that in that case? And you know, they're not similar. They're not the same. They're just not. I've got a story to tell you about that. Many years ago, Rufus Edmiston, who was Attorney General and then Secretary of State, and I were representing in federal court in Wilmington a lawyer from Florida who was charged with drug trafficking. And we went to trial. We didn't enter a plea. He said he didn't do it. He said he was innocent, not guilty. And we went to trial. It lasted about a week and a half. And we thought we had a shot. We thought there was some reasonable doubt there. And we tried the case pretty hard. Judge Dupree was the judge. Turned out that the day the jury went out, there was a hurricane coming in Wilmington, coming up the Cape Fear River near the Hilton and the federal courthouse, you know. And I remember that Judge Dupree would call the jury back in and read to them the weather report when the hurricane was getting ready to hit. Well, we had hoped that the jury would stay out for 5 or 6 hours. My gracious, I want you to know, they were back in about 45 minutes to an hour and 15 minutes with a guilty verdict against our client. They wanted to go home. After that verdict, Rufus and I met with this client before he was taken away. He wasn't in custody at the time. In the grand jury room, which was, I don't know where it is now, but it was somewhere down in the bowels of the federal building on the first floor in Wilmington, this big, nice courthouse. And we sat there, and our client was not happy with us because he'd gotten convicted. And I remember him saying to me, Jim, you certainly did not do a very good job. I can't believe you won the Jeffrey McDonald case, because if you were smart enough to win that case, you sure as heck should have been smart enough to have won my case. That's what I was counting on. And I remember saying to him, I said, they're not similar cases. We did our very best in this case, but they're not similar at all. As it turned out, a year or so later, he turned state's evidence, or decided to cooperate, and admitted that he was in fact guilty and responsible. But I've never forgotten his reaction when he lost the jury trial. Of course, he's unhappy because he's just been convicted. He's facing a prison. He was married, had small children. But he lashed out and blamed his lawyers, Rufus and myself, probably me most, and tried to compare our effort in this case with other cases. You might get that from time to time. You might get that if you have a successful practice. Why did you do so well in this case, but you didn't in this one? So one of the things that strikes me is that it's really important to let clients know that their case is unique. Their facts are unique. You rise or fall on those facts in the law pertaining to those facts. In their case, it's not like any other case exactly. It's just not. And this has a lot to do with leveling with your clients and telling your clients the hard truth. You know, I have to tell you, in my case, plead guilty to all the charges without a plea bargain agreement. When I was arrested, I was under a $25,000 bond. And I suspect, because I've lived in Raleigh all my adult life since I've been a lawyer, that I could have gotten a bond that was not secured, an unsecured bond. Wade and Rick did not want me to get an unsecured bond. They wanted it to be secured. And so we put my house up for $25,000 as security for the bond. I've always remembered that. And even today, I look back in the newspapers when people are arrested and charged with, let's say, white-collar matters, criminal matters, whether or not they put their house up as security for the bond. And so many of them go with an unsecured bond, the promise to appear. I don't fault at all my attorneys for wanting me to get a secured bond. One of the consistent themes throughout the representation that I had was that everything had to be done by the books. There could be no favored treatment. Everything had to be tough. Everything had to be above board, not under the table. Totally. I think looking back at that time in my life is where I first began to learn how to make lemonade out of lemons. I could have taken that matter of security for my house and gotten really angry and put upon and upset. And I didn't. And I think looking back, that was the beginning of taking an adversity and making it something good, because I could then say, well, I had to put up my house for bond, and I have done so. Nobody could say to me, well, you didn't have a bad time, you got an unsecured bond. They couldn't say that. And that was the beginning of realizing how to come back. And I want to stop here just for a second and say, when you give clients legal advice, not psychological or mental advice, straight legal advice that is tough, that they don't wish to receive, they don't wish to get, a good byproduct of that tough advice may in fact be a toughening of them. Did you ever think about that? It could be a toughening of them, and a recognition and a willingness to accept difficult choices. You know, if you have to convince me to take a bond that is secured in the amount of $25,000 by my house, then I'm expecting no breaks, and I'm expecting the next advice and statements you give me to equally be tough. On the other hand, I remember that the State Bureau of Investigation wanted my checking accounts and bank statements and checks and canceled checks for the periods in question. And I remember Rick calling me on the phone and saying that, and rather than issuing some sort of subpoena for them, Rick just said to them, Jim will voluntarily turn them over. And I did. It's not fun, but it was okay. And they went through them. I got them all back. But I remember I got credit for being willing to do that without being forced to do that. I did not want to turn in my law license. Indeed, I got some advice from some other lawyers in Raleigh, some good lawyers, who said to me, Jim, you should not turn your license in, because if you ever want it back, you have a better chance of bargaining now than giving it up and trying to get it back later. I don't know that that's true. I think mine was pretty much a foregone conclusion. But I do think this, by suggesting to me and sort of pushing me to voluntarily give it up before it was done, then I think that, and you have to excuse this clock, I forgot to move this clock. It's about 10 o'clock, it's going to chime 10 times, and it was my mom's clock, and I'm sorry it's going to chime, but you'll just have to bear with it about 10 times while we go through this. I meant to take it away, but rather than interrupt this taping, I'm just going to let you know it chime like that. So that's the one thing I brought from Winston-Salem after she passed away, and I have it here in my living room, and so I remember it fondly for that reason. But going back to my situation here with the bar, Wade said to me, Jim, let's get out in front of this. Let's get out in front and let's turn it over before they have some hearing and issue some complaint, which they would have done. I don't think the decision would have been any different. We didn't have any hearing. I remember that I turned it in and signed, I think there were 4 affidavits. They're a public record, I think. And I signed them, detailing what I had done wrong, that sort of thing, and turned it over. And the state bar later issued a letter of disbarment, which is about 3 paragraphs long or 2 paragraphs long. It's very short. I think in doing that, part of his goal was to take the sting out of everything. Not to make people angry at you. In order for you to get a client to do something he or she is not really wanting to do, like the bond question with the house or turning the law license in relatively early, it was within 3 months of the whole thing falling apart. I think it's important to establish a rapport with the other side. And it's important to convince the client to go forward. You can't do that if you muddy the waters between attorney and friendship. And even though Wade and Rick were my friends, they did a good job on keeping that relationship professional. We didn't go out and drink beer or drink wine or anything like that, or have pizza, during this period of time. We didn't socialize. When we got together during this entire year, it was to talk about my case. The only time I ever had dinner, I think, with Rick Gammon during that time was the night in April of that year when I turned in my law license, and he took me out to dinner that night. So I want to say, to get a client to do something he or she doesn't want to do, you've got to be in charge, and you've got to be willing to talk honestly and tough and frank. That's why it's so important that even though you do this, what you do with the right hand, if the right hand is your fist, and you're convincing the client to do something with your fist, don't forget the left hand, which has some compassion and has some hope built in. And at the same time, you're saying to the client, you've got to do this. You've got to give the client some hope that what they're doing is good. When Wade said to me, Jim, I think you ought to plead guilty to all the charges with no plea bargain agreement, and I said to him, do you think that anybody will ever know really that I did that? Of course they would know, because it would be in public record, in open court. He said, Jim, listen, if you will do that, you will have greater riches than you ever knew. I don't know whether he believed that or not. I have no clue whether he believed that or not. But I will tell you that people admire you when you do the right thing, even when it's tough. People want to see you make lemonade out of lemons. People want to see a comeback story. People want to see people get a second chance. And your clients can benefit from this. If you've got a client who is facing some adversity, figure out and talk to that client in a way that helps them accept that and come back and how to handle themselves. Now, at the same time, this presupposes the client's got some liability. If the client doesn't, then you go to trial, you go to a jury trial or before a judge. But I have to tell you something. I would not go to a jury trial. I would not go to a judge trial unless I thought I was innocent. If I thought I was innocent, then yes, I'd go. But I don't believe I would go otherwise. I wouldn't go on the technicality. I'm going to be found not guilty, or there's a loophole here in the judge's instructions, or the evidence isn't quite strong enough where I believe I can beat it. I don't know that I would roll that dice. I think the thing to do is people like to see you accept responsibility for your mistakes if what you're trying to do is to come back. If what you're trying to do is to have a life after this lawsuit or this case is over. If, for example, you're in a bankruptcy or a foreclosure, or you've been sued for malpractice, or you've got a domestic case, or a criminal case, or whatever, to have a chance to get a second start, you've got to handle yourself during the pendency of this thing as well as you possibly can and be above reproach. And if you do that, and if your lawyers can help you do that, and if you as lawyers and paralegals can help people do that, then that's really, really very important. Let me tell you a couple of instances, though, where paralegals, in my case, really were important. Nobody likes to be told bad news. Nobody likes to tell bad news. And there's a tendency to just sort of dribble it out and see what the lay of the land is going to be. One of the paralegals said to Rick about 2 or 3 weeks after he had started representing me, and Rick said, we're trying to manage the press attention so it will sort of dribble out and not hit people so hard. And she said, oh, I think you're making a mistake. I think what you need to do is let it all come out all at one time and just get it the heck over with. And then it will be done, it will be over with. And then you can see what the lay of the land was. I think she was right. But the important thing is here, she was free to speak up. She was free to give her opinion. The smart lawyer will ask the opinion, the counsel, and advice as paralegal. Really. They got just as much sense as you do. The only difference between you and the paralegal is that you have been to law school and they haven't. They're just as smart, just as capable as you, and may have more street sense than you do. They surely more than likely have talked to the client more than you have. That's unfortunate, but I bet you they have in your case. That can be dangerous, but at least somebody has talked to the client. The other thing that I remember that I will always remember about a paralegal was one of Wade's paralegals. And during 1993, I think in the late summer, an insurance company out of Georgia had decided that I should get some disability insurance on mental health issues of depression. And they gave me a substantial amount of money per month. Believe it or not, 2 or 3 months went by, and I got a letter or a phone call, I don't remember which. And Dr. Spalding had been speaking with them, and they wanted to change the amount that I got. And they wanted to up the amount and give me the maximum possible, which I would get, as it turned out, for 2 years, tax-free. Unbelievable. This all came about because Wade Smith recommended that I go see Dr. Spalding, who got to know me and was my good doctor, and she developed a good relationship with the person who was representing the insurance company. She had validity, she had stature, and she had some gravitas with him, and she knew my case really well and was an advocate on my behalf. You never know where the help's going to come from. And so when you're building a legal representation of a client, don't be afraid to seek other opinion, or let's say to seek outside help. In this case, they got opinions and outside help about me from Dr. Spalding. But going back to the paralegal, the insurance company, for some reason, would not start sending me the larger amount of money until I repaid to them the amount that I already had and spent. I guess a bookkeeping sort of way. So what we did was we went across the mall in Raleigh, went to the bank. I think it was First Union Bank at that time, which became Wachovia, which became Wells Fargo. And we spoke to someone there, and Wade agreed to sign or co-sign a promissory note for 30 days that I could borrow the money, and they sent a cashier's check to the insurance company for this amount of money. And when the insurance company paid back, they would pay the money back. I could go pay the note off, which I did within the 30-day period. It was cold weather. It was probably in the fall or winter at that time when this happened. And I remember going to Wade's office, and we spoke with his paralegal. Wade was out, and she said, "You know what we need to do, Jim?" I said, "What's that?" She said, "We need to go outside and light a match and stand together on the mall and have a burning of the note. This is such a cool thing to happen for you." And we did, and we went outside and we burned the darn note. I have never forgotten that. Didn't take but about 10 minutes. But it was an indication to me that his paralegal was very much on my side, having nothing to do with whether I'd done right or wrong, but very much wanted me to survive and to get through this in one piece. That is so important. It is so important for you and a paralegal to do. What makes a client really like you or want to come back to you? It's so much easier to get clients if your previous clients say good things about you is if they don't say good things about you, don't you think? Well, there's a case here in Raleigh where a friend of mine had a daughter who, and they were going to fly to Atlanta one weekend to watch the Braves baseball games. And they were meeting at the Raleigh-Durham Airport on Friday, I guess, going out for the weekend. And the daughter drove up separately, and she forgot to take her pistol out of her pocketbook. Now, she had a license to carry, a permit to carry the pistol. That was okay. But the pistol was in her pocketbook when she was going through security. And so this, of course, alarmed everyone. The bells and whistles all went off. And they whisked her away to a room and started interviewing her, and she thought she was going to miss the whole weekend in Atlanta. And they finally decided she was sort of a ding-dong about the whole thing, you know. Kept the pistol, let her go on to Atlanta. Saw the Braves game. But they charged her with some offense, and she had to hire an attorney. And it cost her a good amount of money to hire an attorney, and it cost her a good amount to pay the fine that the thing was eventually settled at. The thing that became so important is that after it was over, she tells her mother that she recommends that all of her friends, if they need a lawyer, to go to this lawyer. Go to this lawyer. Why? Because at the end of the day, he walked outside the door. He talked to her for about 10 minutes and gave her a hug. And that's what she remembers the most, that he talked to her and gave her a hug. So the next time you're through with a client, don't just stand at the door and wave goodbye. Walk outside. Walk to the car if it's outside your parking lot. If it's on an elevator, ride down to the first floor with them and go to the lobby and say goodbye. They will always remember that. You're not required to do that. They wouldn't blame you if you didn't do that because they know you're busy. But let me take a victory lap or whatever it is and go down with them and do that. They will remember that personal touch. One time when I was a lawyer, I had a friend who had a young daughter, who was at Crabtree Mall in Raleigh, and she was possessing some illegal drugs that were very serious. She had not yet been indicted. She'd just been charged and arrested, but it was in district court, and we were trying to keep it from going to superior court, because if we went to superior court, it became much more serious. So we were trying to keep it in the district court. I talked to her with her father and without her father, and she denied any wrongdoing and denied the whole darn thing. And she took a polygraph exam, which she did not pass, but she would not admit she was culpable in any way. She thought it was a total accident or a setup or something. Finally, I talked to the people in the pretrial diversion or felony diversion program and realized and got it to, and anybody could have done this really, it wasn't anything special that I did, anybody could have done this, that if she would write a letter sort of admitting responsibility, then, and she behaved herself at the end of her probationary period, maybe a year, maybe less, that she would be set free with nothing on her record. Her record would be expunged. And then she was just graduated in high school, or she was a senior in high school, and her ability to go to college would not be jeopardized. And after much tugging and twisting and hollering and shouting and screaming, sitting out in the courtroom lobby on the one of the floors of the Wake County Courthouse, she actually signed a letter that we wrote for her. And we went to court, and it was over in a matter of minutes. And she went on to college, and I think is living a very nice life. That's the best example that I think I can give to you of when you start out, what is it that you want to achieve? In her case, we wanted to achieve something that would not hurt her and hurt her ability to go to school, to jeopardize her ability to go to college, to not have a felony conviction, for example, on her record, not to risk jail time, not to risk a fine, not to risk anything if we could resolve it some other way. And we were able, to do that, for which I am very grateful. In my case, I think, looking back, I used to go through periods of doubt. During the year of 1993 and subsequent years, even when I started doing some of these programs, I would somewhere doubt whether or not I had done the right thing. And I think, looking back, I have to come to the conclusion that we did do the right thing, because we were able to survive and to start over and to build a new life. And if I had gone a different way, if I had been adversarial, if I had challenged things, it wouldn't have worked out that way. And some of my friends said, well, Jim, you really didn't have much of a choice because you were guilty, dead to right. You left a paper trail. That's certainly true. But, I could have made people prove it, which would have been such a stupid mistake, because they could have proved it. It wasn't tough. It wasn't a hard decision to do. I am struck all the time when I read in the newspaper, I see friends of mine who are really prominent lawyers in North Carolina say, well, if such and such a client is found guilty, they're going to have a chance, they're going to have a significant chance to spend time in prison. Or they're going to have to, their life is over they will have lost everything. Let me just say this to you. That may be true. I don't fault any of that concept. You may lose, if you're the client, everything you struggle to get. But if you have lawyers who look out for you as an individual, and if you are a lawyer or a paralegal who looks after clients as individuals and help them make decisions that will stand the test of time, that might in the initial stages be tough or harsh, and get out in front, then even though you as a client may have lost everything and have to start all over again, you as a client might have that chance to do just that. And I would argue to you as a lawyer or a paralegal that if you assist or help someone who is clearly in jeopardy, in trouble, accept what's coming, accept what is the unacceptable up to now, and take a fall but with some grace and dignity, then that client has a chance to start his or her life all over again. That's possible. You have to take the long view. Don't just take the short view. Just don't take the case that's just coming up and it's over with now and I won't see you again or talk to you again. I know there are lots of cases where you do that because you got lots of clients and you can't handhold every single client. I'm not saying that you have to handhold anybody at all. I'm just saying that giving people straight advice, honest advice, the tough truth, making tough decisions, making hard decisions, doing it appropriately and quickly, cutting your losses if you have to cut losses, and getting out in front and making a parade, getting run out of town on a rail look like it's a parade, then that's a smart thing for you to consider doing. You know, Wade used to say to me all the time, he said, Jim, I have always heard it said that if you bear a cross with dignity, it will end up bearing you. If you bear a cross with dignity, it will end up bearing you. That's not legal advice. I don't know what kind of advice that is, but it's good advice. Do you know, I used to say to Wade, I just don't really believe that. That's sort of Pollyanna type talk. He said, but Jim, it's true. He later told me, he represented one of the athletes in the deep lacrosse case several years ago. And he said that one of the mothers, or the mother of his client, when she would call him or send him emails or write him notes about his case, she would oftentimes quote back to him, you know, what's said, what he said, that same line about bearing a cross with dignity, and it ended up bearing you. Now you may note in this particular hour I have talked about representing a client who is facing adversity. And maybe you are representing a client who's not facing adversity. Maybe you're representing a client who's on the other side, who's suing somebody or bringing some action against somebody. But even so, even if you're doing that, you want to give them good, solid, tough advice as to how to handle themselves and look for the big picture. Know when to cut and run and settle, know when to go for the jugular, but what you should do. You know, there will be a life after this case for you as a lawyer. You will have other cases. You will have other clients. This case will go away and be put in a file in a storage area somewhere. You may even forget the name of your client. But I will promise you, it will never stop for the client. The clients will always remember every kind of case they've ever been on, even if it's a traffic ticket case. They will. And they will remember you as their lawyer and how you acted for them and what you did for them, quite frankly. They're going to remember that. And so I would just say to you from the very outset, be willing to give your clients truthful, tough advice. You know, in the last 15 or so minutes of this presentation of hour 2, let me first by asking you this question. How important is it? How important is it that you give your clients honest advice and get them to make tough decisions? Why is that so important? I think it's important because you give the client a chance to start over after the case is done. So why do you make tough decisions? Not just because you have to, but because people respect and admire anybody who makes tough decisions. They really will. A few weeks ago, I was at lunch on a Sunday morning, and we were in a restaurant here in Raleigh, and a bunch of us, and I saw this man across the way, and he saw me, and he waved to me. And I got up from where I was sitting and went over to speak with him. And we stood there, the two of us, in the middle of the restaurant, talking to each other, shaking hands, and asking how each was doing. And I wished him well, and he wished me well, and said to me, you know, you're doing okay. I said, well, life has a strange way of working out. He said, well, yes, it does. I tell you this story because he was the Superior Court judge who sentenced me to prison. That's pretty full circle for me, as much as I can get full circle, I suppose. And I think that has come about because back in 1993, now over 20 years ago, we set out to handle my case in a way that you could put on the front page of the paper, to be open, to be transparent, to talk about mental illness, to talk about depression, to apologize, to do all these things, and to do it as quickly and as honestly as possible. That 20 years after that, the Superior Court judge, who is still a sitting Superior Court judge, is able to say, I'm glad to see you and that you're doing well. That's the sort of result you want for your client. That, I would argue to you, is a win. That is not a loss. I think that's a win. Now, fast forwarding just a moment to another situation. Years ago, when I was very young, I was assigned to prosecute Jeffrey McDonald for triple murder in Raleigh, federal court. And the trial took place in 1979. It took about the whole summer to try the case. And the truth about the matter is, I thought we had a great chance of convincing people that he did it. I thought we had a terrible shot at winning the case because I didn't think a jury would vote to convict. So we thought we would prove that he did it, but we just didn't think we would win. And the reason we thought that is because that's where we thought the evidence was, whether you agree or disagree. Anyway, years later, in 2005, a motion was filed in federal district court in Wilmington challenging this conviction based upon allegations of prosecutorial misconduct and the allegation that I had said something to a witness that I should not have said, causing her to change her trial testimony. This motion is still pending. It went on for a long time. There was a hearing in federal court a couple of years ago in Wilmington. And I will say, as I said in the manuscript to this program, that those charges are not true, that conversation never took place. But the issue that I want to talk about is not that right this moment. The issue is conflicts. When are you free to represent somebody? How can you be a zealous advocate for somebody? And so I remember Wade saying to me when he first told me about the possibility of this motion, he said, "Jim, I don't think you should worry about this because I can't represent McDonald because I was your lawyer and there's a conflict." And subsequently, fast forwarding a few weeks, I subsequently signed a written multi-page waiver so that Wade could in fact represent McDonald. He subsequently did not represent McDonald because of conversations that he and I had and my reaction to some of the statements that were made in the motions, and so he withdrew from this representation. My question to you is, and it was appropriate representation, the bar, I don't know if the bar signed off on it, but he was free to do so. He had a perfectly legitimate waiver that I signed freely, without any or anything like that, that he allowed him to represent McDonald in this matter. The question I have to ask you is this. First, how do you handle that kind of situation? I remember asking Wade when we got upset with each other, "Wade, if you're in the courtroom and I'm on the witness stand and you're having to ask me some tough questions, won't that make you feel bad?" That was my standard. "Won't that make you feel bad?" And he said, "Well, I may not be the one asking the question, someone else would." I said, "Well, you're still on that side." And so my question to you, or suggestion to you, is what's the standard that you should use as to whether or not you can represent someone in a legal matter and someone that you once represented is on the other side? Can you do that? Can you go back and forth? And I don't know the answer to that. You can call the bar and see what the bar says, but I suspect they're going to say something like, it depends on whether or not you can represent your new client zealously, without any evasion, without any compromise, that you can go out full force and do the best that you can. If you can do that and satisfy yourself that you can do that, then yes, go ahead. I have to tell you, if I were practicing law, I would be afraid about pulling my punches, that I might not go quite as hard as I should go. And so I would say to you that the area of conflicts is a very awkward, difficult aspect of law. And I would say in representing clients, in order to be a great lawyer and to represent your client zealously, totally, with passion, I think you've got to be sure there is absolutely no clear conflict, indirect conflict, or implied conflict. Because I think if you do, if you're normal, if you're human, it's going to impact you and your ability to be a really good lawyer for that client. The second question, I guess, is everybody assumed that it was my waiver, my privilege to waive, which I did. And yet, by what I have just said, is it may well have been McDonald's privilege to waive. I suspect he would have waived it. I don't know, but I suspect he would have waived it. He never got that chance. But I sort of think it was McDonald's chance to waive it. The reason I mentioned this here at the close of this particular hour is because I think conflicts and representations is very important. When I was practicing in Raleigh and we had a big office in Greensboro and Charlotte, oftentimes we'd get conflict questions and I would get bounced out of representing somebody because somebody else had represented somebody in some other matter down the road in the past. And that always bothered me. I always didn't like it because I was losing case after the conflicts check. But there's a good reason for conflicts check. It keeps things straight. It keeps you out of trouble. And so I guess my question here is what is the standard that you should hold yourself to as to whether or not you can get a waiver of a conflict and still represent somebody even though you represented that side of the other side in a previous matter? And I guess the answer that I'm looking for here is it's really a judgmental decision on your part as to whether or not you can represent the client zealously, with full passion and fully and completely as you would if there had in fact been no client. That's what I would say. You know, so send me the answer to that question as well as the other one for this second hour. We had that hearing in the McDonald case in Wilmington in September of 2012. It went on for about a week and a half, and I was a witness on about the third day of the hearing. And I testified one afternoon and was on the witness stand for about 2.5 hours. I remember walking in the courtroom, it was packed, lots of people there, and walking around to the side and raising my right hand and swore to tell the truth. It takes a very few minutes just to do that, very few seconds really to do that. And I remember all the time when I was a lawyer that would happen. I didn't really pay a lot of attention to that when I was a lawyer sitting at a counsel table. I want to say to you now that of all the things I have done, that was a very solemn moment to me, to swear to tell the truth, the whole truth and nothing but the truth. So help you God. Standing here in front of this camera is not so tough. I can do that. Seeing it in a courtroom with a judge and lawyers on both sides and being ministered to you is a very solemn, important moment. I think when you're representing people in a courtroom and someone is going to take the witness stand in front of a jury or a judge, either one, this was a judge, not a jury trial, then let them know how important and how solemn and how critical it is that they do this. And they do it well, and they understand how significant and how important it is to tell the truth. I remember the night before I was to testify, I got an email, a very short email from my friend Joe McGinnis, who has now recently passed away. He was also going to be a witness in this case. He wrote the book Fatal Vision about the case, and he was a witness because he was present during a meeting with the same witness that I was supposed to have pressured when she met with the defense team, because he was taking notes for the book. He had lived with the defense during the trial, and so he was going to testify about that. Well, he wrote me an email the night before I was to testify, and it went like this. He said, "Jim, you look great. You'll do great. The truth is hard to screw up, unlike lies. Joe." I still have that email. It was sent at 12:03 a.m. in the morning. I want to say to you, if you're a lawyer or a paralegal and you're dealing with clients or people who become witnesses in cases or in matters, and they have to testify in court, whether it be in front of a judge or just in front of a jury, the words that Joe wrote to me are really pretty significant and really pretty important to say. And it goes like this: tell the client or the witness they look fine, they look great. They really do. They're going to do fine. They're going to do okay. It's all going to be all right. Just tell the truth. Just tell the truth. That is all you have to do. And if you do that, the other side can't trap you. Oh, they may ask you some tough questions. There may be some awkward questions. There may be some embarrassing questions. But they can't trick you up. You can't commit a crime. You can't commit perjury. You will be an effective witness if you answer the question honestly, truthfully, and openly. I'll talk more about that in the third hour, a little bit more, what I think about that. But my impression was, when I was an attorney, I wished I had spent more time with people who were going to testify. And I'm sure I talked to them some, but I really wished I had, to let them know what to expect, how important it was to be open and transparent and to tell the truth and to listen and to do that. That's a big part of being a lawyer, is to represent your client in court and tell them how to conduct themselves and how to behave themselves. I hope you've enjoyed this second hour. We have one more hour to go, and then you will have finished this 3-hour program of Good to Great, lawyers, paralegals, and clients.